SwayamPrabha. Digital India. Educated India.
Hello friends, in this 7th session to the course of law relating to women and children, I have come with the topic early childhood care and education in India. In this lecture, I will discuss about the status of early childhood care and education in India, what are the constitutional status of the early childhood care and education, what is the constitutional mandate for early childhood care and education, and what are the legislative initiatives on the part of Union Legislature, that is Indian Parliament, and the state legislatures of different states. What is the international law relating to early childhood care and education would also be discussed. Friends, early childhood is the supreme asset to any nation, and therefore, the nurture and the solicitude of early childhood is the responsibility of the state, is the responsibility of any country. The effective plans for ensuring the early childhood care, protection and education should be adopted so that the children may grow to become the robust citizens, physically fit, mentally alert and morally sound, endowed with the skills and motivations. Only then these children can be transformed into a effective and the sound human resource of any country. As to the introduction to the topic, the early childhood, the meaning of early childhood, it refers to the formative stage of first 6 years of life of a child. This crucial age of first 6 years has well marked stages in the growth and development of a child, having stage specific needs. The early childhood care and protection, this issue becomes more sensitive because this stage of the children has many different or diversified needs. These needs involve inseparable elements of care, health, nutrition, play and early learning with protective and enabling environment. This stage of development of a young child builds inseparable foundation of lifelong development and learning, which has lasting impact on overall development of a child. The researches and scientific studies made at the national and international level, including the studies made by the National Institute of Educational Planning and Administration, New Delhi, and European Commission, it has been pointed out that the pace of development is exceptionally soaring during first 6 to 8 years of a child's life, when a great deal of the potential for adulthood intelligence is realized. In this context, it is the fact that quality early childhood care and education is an essential factor for all prospective learning, education, social integration, individual growth and enduring accomplishment in the life of an individual. In the case of Sheela Varse versus Union of India, the Supreme Court opined that nation's children are supremely important assets. Their nurture and solicitude are our responsibility. children's program should find a prominent part in our national plans for the development of human resources, so that our children grow up to become robust citizens, physically fit, mentally alert and morally healthy, endowed with the skill and the motivations needed by the society. Equal opportunities for development to all children during the period of growth should be our aim, for this would serve our large purpose of reducing inequality and ensuring social justice. So, it has been the opinion of the Supreme Court that for reducing inequality and for ensuring social justice and to make the children of the country as the robust citizens who are physically fit, who are mentally alert and who are morally sound or morally healthy. The right of care, protection and education to early childhood or to the children should be recognized. It has been the opinion of the Supreme Court in Sela case that no country and particularly our country cannot ignore the issue of the subject of early childhood care, protection and education if we want to be the progressive nation, we want to be the developed nation, because there would be the contribution of the present children in the future as the human resource, and all these motivations, all these skills and all these requirements are needed in any child for becoming a robust citizen to contribute in the progress and development of any country. Therefore, the supreme law of the country should be capable of guaranteeing the basic rights to protection, care, education and development of young children, so that they may stand on such well-built foundation for their lifelong learning and the development. Though in India, it has been the constitutional goal to make proper initiatives for ensuring child care, education and development, yet it seems that this aspiration of our founding fathers still remained unrealized. It is regrettable that we could not develop any legal framework at union or state level to deal with specifically on the subject of early childhood care, protection, education and development. The union legislature and that of some states have enacted several legislations to address the various issues of children generally, and therefore, having some impact on these matters of early childhood. These legislations relates to the care, protection, health, nutrition, education and development of children in India, but no specific legislation could have been made by Indian legislature to deal specifically with the subject of early childhood care and education. Neither in the constitution itself, no express provision could be included in the part 3, that is the fundamental right, chapter of fundamental right or the part of fundamental right, wherein the fundamental right to early care, early protection and early education of the children could be protected, could be guaranteed. It is also true that the sufficient fortification, care and encouragement at this stage of childhood may shape a sound foundation for the forthcoming well-being and innumerable development and growth in bodily, psychological, collective, lingual, logical and analytical competencies of the child. Makers of our constitution conferred the responsibility of care and learning of early childhood on state by including this topic of or the subject of early childhood care and education in part 4 of Indian constitution, that is the part where the directive principles of state policy are provided. The makers of Indian constitution were of the opinion that though we are not recognizing the express fundamental right of care, protection and education of the childhood, but it would be the responsibility of the state within its financial competencies, within its financial capacities, that the state or the nation should take care of the early childhood care and education, but it could have not been done and it was neglected on the part of the state policies or state legislations. Early childhood education and care is not important only for the individual growth, development and social progress, but it is also equally significant for economic growth and development of a country. It is one of the prime means rather than only means for building the human resource capable of ensuring the social and economic development of the society at large. Early childhood care and education refers to the synchronized inputs of care and opportunities for psychological, social and educational development in an enabling environment for all children from birth to 6 years of age. In the report number 259 on early childhood development and legal entitlements by the Law Commission of India in 2015, it was observed, it was recognized that early childhood care, protection and education is a very important issue, and there shall be the legal entitlements for the care, protection and education of early childhood in India. Article 25(2), if we see the international initiatives, Article 25(2) of Universal Declaration of Human Rights, which represents the first global assertion of universally protected fundamental human rights. The UDHR enunciated the special rights of child for the first time by providing that motherhood and childhood are entitled to special care and assistance. In 1948 itself, when the UDHR, Universal Declaration of Human Rights, was adopted by international community on the initiatives of the United Nations, it was recognized that the children should need special care, special protection and special methods of education. That was considered to be the basic human rights of children, that they should have the guarantee of care and protection. But in India, we could not transform this message of international or Universal Declaration of Human Rights, UDHR, into the reality. Then in 1989, the United Nations adopted the legally binding Convention on the Rights of Child. So it seems that the United Nations or the international community in the leadership of United Nations has been very cautious and careful about the rights of early childhood, about the care, protection and education of early childhood. Even in the first document which was agreed to by the international community in the form of Universal Declaration of Human Rights to protect the human rights of the human being all over the globe, all over the world, it included the human right of care and protection of children. Then in 1989, the next convention on the rights of child was adopted by the international community on the initiatives of the efforts of United Nations. In 1989, the United Nations adopted the legally binding Convention on the Rights of Child, which is widely known as CRC, the Convention on the Rights of Child, ratified human rights treaty in the world. It is the most largely ratified human rights treaty in the world. The convention emphasizes the right of all children to protection, care and education. Then the World Declaration on Education for All at Jomtien in 1990 introduced the idea that learning begins at birth and affirms early childhood care and education as an integral part of basic education and an educational level in its own right. The next initiative which was taken by the United Nations in this regard, the UN Convention on the Rights of Child provided for the constitution of the monitoring body, the United Nations Committee on Rights of Child. Article 43 and 45 of Convention provides the procedure and responsibilities related to the composition and the functions of this committee. United Nations Committee on the Rights of Child. The committee consists of 58 independent experts elected by the ratifying members and countries. The Moscow World Conference on Early Childhood Care and Education, building the Wealth of Nations, convened the Director General of UNESCO, was held in Moscow, Russia from 27 to 29 September 2010. Then on 20th November 1959, even earlier to the CRC, the Declaration of Rights of Child was adopted unanimously by all then members states of United Nations General Assembly. In 1959, Declaration recognized universally the child as a human being who must be able to develop physically, mentally, socially, morally and spiritually with freedom and dignity. The preamble of the Declaration highlights children's need for special care and protection, including appropriate legal protection before as well as after birth, and accordingly, the Declaration of Rights of Child 1959 lays down various principles to fulfill these activities. The International Covenant on Civil and Political Rights, that is ICCPR, adopted by UN General Assembly in 1966, was an earliest international instrument recognizing the child's right to protection. It is relevant to refer that the responsibility of ensuring protection to the child was assigned to the family, society and the state. India ratified this convention in 1979. Then Health for All Declaration 1978 is also an initiative in this regard. Now see the constitutional mandate. After discussing the various initiatives on the part of international community in the form of international law to protect the right to care, right to protection and right to education of early childhood, we are to see that what is the constitutional mandate in India in this regard and how the Indian constitution and then the legal framework in India could pursue or could follow, could adopt the message or the declarations which were made by such international instruments or the international initiatives relating to the rights of early childhood. Under the constitutional mandate, I would like to refer first Article 15(3), wherein the state is authorized to take special initiatives for the children and the positive or affirmative discrimination can be made in favor of the children. With regard to the judicial opinion, the case of Unni Krishnan versus State of Andhra Pradesh, which was decided in 1993, can be referred to, wherein under Article 21 itself, the right to education of the children up to 14 years was recognized. And it is also relevant to refer the decision of the Supreme Court of India in the case of People's Union for Civil Liberties versus Union of India and others, decided in 2001, which recognized this important right of children, that right to life has to be comprehended and interpreted in the light of directive principles of state policy enshrined in Article 41, 45 and 46. It was also enunciated that every citizen, including child, is entitled to right to nutrition, right to food and right to health, as these rights are intrinsic constituents of right to life under Article 21. So, when right to food, right to nutrition, right to health are the intrinsic constituents of right to life under Article 21 for every person including the children, then certainly it is the obligation imposed over the state by the Constitution of India through the directive principles of state policy enshrined in Article 41, 45 and 46, that the state should take measures, the state should take initiatives for guaranteeing the right of care, protection, education and nutrition of the early childhood. It is the responsibility of not only the family, it is not the responsibility of only the parents of the child to take care of the nutrition, health, food and the protection. It is the duty of, at the same time, it is the duty of the state itself as per the constitutional mandate given by the directive principles of state policy in article 41, 45 etc. Such interpretation was made by the Supreme Court in the present case, and the obligation was imposed by this interpretation on the state to take care of the education, nutrition, food and development of a child, which includes also the education, and therefore, a child is also entitled for the right to food, right to nutrition, right to development, right to education and right to protection. Indian Parliament amended the constitution in 2002 by 86th amendment. We have also discussed this aspect of the right of early childhood under the lecture, the constitutional law or the constitutional protection to the women and children, and therefore, I will not go in details of this 86th amendment. Here at this point of our discussion, I would like only to refer this 86th amendment, because it is relevant with respect to the right to education, right to care and right to protection of the early childhood and the issue of care, protection and education of early childhood. 86th amendment included article 21A in Indian constitution, but it recognized the fundamental right of education of only the children of age group from 6 to 14 years, and the children from 0 to 6, these were not included within the ambit or scope of article 21A. Within the same amendment, article 45 was also reworded or substituted, wherein the directive was given to the state to take care of the care, protection and education of early childhood or the children from 0 to 6 years. I have also referred to the report number 249, Law Commission of India on Early Childhood Development and Legal Entitlement, Chapter 3, the Constitutional Context 21, 2015. The report says that such exclusion of early childhood from the scope of enforceable fundamental right under article 21A amounts to the denial of care, education, proper growth and development to the children of this age group. So, this is the opinion of the Law Commission of India, that the exclusion of the children of the age group from 0 to 6 years from the enforceable fundamental right under article 21 is the denial to the right to care, right to protection, right to education of the children from 0 to 6 years. It is also important to refer the Venkatachalaya Commission report again. That Venkatachalaya report commission also recommended for the inclusion of this age group within the scope of article 21A as the enforceable fundamental right, and in this regard the commission was the opinion that under part 3 article 30C should be included, article 24A should be included and the article 21A should be amended to include the children from 0 to 6 years. It means by these 3 amendments, it is clear that the Venkatachalaya Commission was of the opinion that the early childhood or the children from 0 to 6 years should also be given the right or should also be guaranteed the right to care, protection and education. In Sheela Varse versus Union of India, the Supreme Court recognized the duty of the state to take care of children with a view to ensure the development of their personality to its fullest, because these children are the asset of the nation their care, protection, encouragement, fostering and promotion are the prime responsibilities of the state. It is a scientific fact that the health of an infant child is dependent of the health of the mother during gestation, and there is very intimate relationship in the health of the baby and health of the mother during conception. The Supreme Court of India has recognized this cherished and close bond between the child and the mother and observed that central and state governments are accountable for introducing integrated child development services schemes not only to all children below the age of 6 years, but also to the expecting women and lactating mothers. Then the People's Union for Civil Liberties, not Central Liberties, Civil Liberties, People's Union for Civil Liberties versus Union of India. In 2006, this accountability, the Supreme Court was of the opinion that this accountability imposes an obligation on the state to enact such laws, lay down such policies and to come out with such schemes and programs whereby this great objective of making the children the robust citizens of the country may be turned into reality. But it is regrettable that despite such an explicit acknowledgement by the Apex Indian Court in 1986, even after 37 years, there is no central legislative framework which exclusively and expressly deals with the health, nutrition, care, education of the children below 6 years. However, there are some union laws that relate to and have some impact on these significant issues of childhood, and therefore, it is also necessary to go through those legislations which cover the different aspects of the care, protection and education of the early childhood. Though we do not have any specific law on the subject, but there are different legislations being enacted by the Union Parliament and the state legislatures which cover different aspects of early childhood care and education. This study of the legislative framework may be divided into two: the Union legislative framework and the state legislative framework, meaning thereby the legislations which have been enacted by the Union legislature and the legislations which have been enacted by the state legislatures. In this series, the Children's Act 1960 comes at first place. This Children's Act 1960 was enacted with an objective to provide for the care, protection, maintenance, welfare, training, education and rehabilitation of neglected or delinquent children in Union territories. The Act is applicable to neglected children and the delinquent children. Under section 9(1), for the reception of the neglected children, the children's homes are to be established and maintained by the administration. Under the Act, when a neglected child is sent to the children home, it is the duty of the children home under section 9(3) to provide for the accommodation, maintenance and the facilities for the education of that child. So, this provision of the enactment take care of the education of child also, but the applicability of the legislation is confined only to the Union territories and it is confined only to the neglected and delinquent children, not to all the children. Under section 9(3), it is also the duty of children home to make available the facilities required for the development of his character and abilities, to ensure the basic training for making him capable of protecting himself against any kind of moral danger or exploitation, and to take any other initiatives for ensuring all round growth and development of the personality of the child. Under section 17 of the Act, it is provided that if there is any complaint of a parent or guardian of a child that he is unable to do proper care or to exercise proper control over the child, and satisfactory grounds are found to initiate the inquiry regarding the child may be sent to an observation home or the place of safety. So, the Children's Act 1960 seems to be a progressive legislation made by the Union Legislature to take care of the protection and education and development of the children, but the scope of the legislation is confined only to some kind of children. These are neglected children and the delinquent children. Further, the scope of the Act is limited because it is applicable only to the Union territories. Then the next legislation comes, that is National Food Security Act 2013. This National Food Security Act 2013 recognizes the intimate relationship between the health and nutrition of a child and mother and provides for nutritional support to pregnant and lactating mothers, considering and appreciating the special needs of expecting women and lactating mothers to ensure health and nutrition of the prospective child. The Act entitles such women for free of charge meal during pregnancy until the 6 months after the birth of child under section 4A of the Act. In addition to this, the maternity benefit of minimum 6,000 rupees has also been granted by the Act to those pregnant and lactating mothers who are not in any government employment or not receiving any such benefits under any other law. Under section 4B, it is provided. Then the supplementary nutrition rules 2015 were made under the Act with an objective to bridge the gap between the nutritional support to the children in the age group of 6 months to 6 years, that is the age of early childhood, has been guaranteed by making their entitlement to free of charge age appropriate meal under section 51A. It seems that the right to food to expecting women, lactating mothers and the children has been guaranteed with a view to meet the nutritional standards. These rules recommended dietary allowance and the average daily intake. Rules also provide for proper monitoring and for enforcing quality standards for meals. The distinctive features of rules is to make the provisions for special categories of beneficiaries under the ICDS, including children in the age group of 6 months to 6 years. So, again the children from 6 months to 6 years, that is early childhood, was taken care of. Then in this series one more act comes, that is Juvenile Justice, Care and Protection of Children Act 2015. This act was enacted to provide for proper care, protection and handling of the children in need of care and protection. Children in need and protection of care are defined in 214, subsection 14 of section 2. So, it serves the basic needs for their development and espousing a child friendly perspective. For this purpose, section 2 subsection 13 and section 2 subsection 14 of the Act distinguishes between children in need of care and protection and children in conflict with law. Two kinds of children are addressed by the Juvenile Justice Act: children in need and care or children in need of care and protection, and number 2, the children in conflict with law. The children in need of care and protection comprises the children who are in adverse conditions and are in need of state support to become responsible citizens, whereas the latter, that is children in conflict with law, are the children who are involved in criminal activities. Under the Act, particularly under section 27(1) of the Act, the state is obliged to constitute for each district one or more child welfare committee to exercise the powers conferred and to discharge the duties assigned by the Act. The committee is the final authority to determine the cases relating to care, protection, treatment, development and rehabilitation of the children. It is also obliged to provide for their basic needs and protection of human rights under section 29, subsection 1. We will discuss this particular legislation, the Juvenile Justice Act, in detail in the later lecture when we will deal with the protection of children under Juvenile Justice Act. The next initiative on the part of legislature, Union Legislature, the Maternity Benefit Act comes. The Maternity Benefit Act 1961 is a significant and vital legislation relating to the issue of care, protection and education of the children below the age of 6 years. The most important objective of the Act is to ensure inclusive health care to the woman and her child when she becomes unable to perform her work due to the adverse conditions of health. So, for the purpose or for the protection of the care and health of the child, the maternity benefit was recognized to the women under the Maternity Benefit Act. It was realized by the Indian legislature that there is a need for maternity benefit so that mothers may become able to share quality time for proper and efficient care, education and protection of their children without any concern and stress about the continuance of their employment. And therefore, the Maternity Benefit Act seems to be a relevant law for the purpose of supporting or assisting the care, protection and education of the childhood or early childhood, because without the proper care by the mother herself, the proper care and protection cannot be given to the children, and this maternity relief by the legislature, by this legislation, by this act to the women certainly guarantees the right to protection, right to care and right to education of the early childhood, where the mothers are given the opportunity to take care of their children in this early age by taking the maternity leave without any apprehension in their mind that whether their job or their employment shall continue or not, by taking such a long leave for taking care of their children. So, the security has been provided to the women employees for taking care of their children. The Act protects the employment of women during maternity and entitles them to fully paid absence from work with a view to take care and protection of child. It is the responsibility of the employer to communicate the women about their entitlement for every benefit available under the Act at the initial stage of their appointment and to provide them maternity benefits under section 11A2. Under section 2A and 2B, the Act is applicable to women working in factory, mine, plantation, any government establishment, performance, industry and any shop or establishment having employed 10 or more persons. So, Act is also applicable to the shops and establishments or industries, even the private employments where the employer has 10 or more persons to employ. In this series, the next legislation enacted by the Indian legislature is the infant milk substitutes, feeding bottles and infant foods Regulation of Production, Supply and Distribution Act 1992. This seems to be an important legislation relating to the health and nutrition of infants in India. The Act recognizes and appreciates the importance of breastfeeding. Therefore, it prohibits all kinds of promotion, advertisement, sale, distribution and sponsorship of infant milk substitutes, feeding bottles and infant foods with a view to protect breastfeeding from adverse impact of commercial and marketing purposes. The Act also provides for proper education, understanding and awareness to the pregnant women and lactating mothers about the benefits of breastfeeding for the health and nutrition of their children under section 7. In 2003, the Act was amended with an objective of its effective implementation with a view to review the development in the area of enforcement of the Act and to recommend measures for its effective implementation. The National Steering Committee on Breastfeeding and Infant and Young Child Feeding was created in 2013. Then, the Rights of Persons with Disability Act 2016. It mandates the governments and the local authorities to take appropriate initiatives for prenatal and postnatal care of mother and child under section 25F. This is important because the right to early childhood care, protection and education has been recognized by the international community and instruments as a universal right granted to all the children, and therefore, this opportunity should also be given to the disabled children. Friends, it becomes more significant with reference to the children with disabilities who require a special attention for making them capable of accessing their rights. The legislative initiatives addressing young children as a group with disabilities and malnutrition, etc., certainly ensures better care and protection to them. It seems that a legislative classification of children under 6 years as a distinct group with specific entitlements in such legislations can be way forward in this direction. And therefore, it is required that in such legislations where such demarcation has not been made and all the children are entitled, there should be the separate group of the children from 0 to 6 years and the separate entitlements should be given to them because of the fact that these children who are in the age group from 0 to 6 years, they are distinctive from the other children and they have their age specific needs and therefore, they cannot be compared with the entitlements of the other children. The specific group should be created in such legislations and particularly in the Persons with Disability Act of the children from 0 to 6 years, so that the issues of or the concerns of the early childhood may also be taken care of, especially in these legislations. In 2009, the Right to Free and Compulsory Education Act was enacted. We all know, as I have already discussed in at least 2 lectures, about the 86th Amendment in the Constitution and recognition of a fundamental right to education of children. In pursuance to that constitutional amendment made in 2002, in the year of 2009, the right to free and compulsory education was enacted. Right to free and compulsory education was enacted to fulfill the constitutional obligation which was created by the Indian Parliament through 86th Amendment. And this Right to Free and Compulsory Education Act 2009 is the only union legislation that directly deals with the early learning education. The Act makes it the responsibility of the government to provide for necessary arrangements for pre-school education, keeping in view to prepare the children above the age of 3 years for their elementary education and to ensure early childhood care and education for all children up to the age of 6 years under section 11. So, it seems to be very progressive legislative initiative in the form of section 11 of Right to Free and Compulsory Education Act 2009. First time in the Indian legislative history, the early childhood care and education was recognized as a separate subject to be dealt with by a separate legislation. Though the education of early childhood or the education from 0 to 6 years was not recognized as fundamental right, in contrast with the right of the children of age group from 6 to 14 years, but the responsibility was given to the state or the government to take care of the proper care, protection and education of the children below 6 years. And therefore, the Venkat Commission recommended for the amendment in Article 21A, and similar amendment may be recommended in section 11 of the Right to Free and Compulsory Education Act 2009, so that the early childhood may also be entitled to the right to education as the fundamental right. For achieving the commendable goal of early childhood care and education, it is important to amend this act and amend the constitution, because this provision has not been made mandatory and it is left on the discretion of the state to make the arrangements for early childhood education and protection. The crèche facility is also one important aspect of early childhood care, protection and education. The provisions for crèche facilities were included in different legislations with a dual objective: to reduce the professional isolation, for providing encouraging and sprightly working environment for women, and for proper care, protection and education to their children as well. For example, the Factories Act 1948 mandates any establishment with more than 30 women workers to set up crèche facilities for ensuring care, protection and education of children and infants of working women. It is the responsibility of owners of such establishments to set up crèche facilities. They are required to provide satisfactory, sufficient, clean and hygienic accommodation to such children under the services of trained caregivers. This is provided under section 48 of the Factories Act. The provision for providing for the crèche facility has also been made in the Beedi and Cigar Workers Act 1966. It also requires every industrial premise having more than 30 female employees to provide and maintain crèche facility to the children under the age of 6 years of such female employees. Again, the responsibility has been imposed over the employer that such crèche facility should provide sufficiently and adequately lighted, ventilated and maintained accommodation in clean and hygienic conditions. These care facilities are required to run under the charge of such women who are educated and skilled in the care of the children and infants. Section 14 of the Beedi and Cigar Workers Act 1966 provides this. Under the State Migrant Workmen Act 1979, the contractor or the principal employer of every establishment with 20 or more migrant workmen is obliged to provide crèche facility for their children under the age of 6 years. And this crèche must have at least one playroom and one sleeping room along with sufficient number of toys and games in playroom and cots and beddings in the sleeping room. The crèche is required to be capable of giving adequate protection against heat, damp, wind, rain and providing sufficient ventilation and lighting. It is also required that such crèche facility must be situated from a convenient distance from the establishment and must have supply of drinking water in sufficient quality. Building and Other Construction Workers Act 1996 and Plantation Labour Act 1951 also provides for the crèche facility for children under the age of 6 years with adequate and sufficient accommodation, ventilation, lighting and sanitation. Then we are to see that what are the state legislations in this regard. The initiatives made by the state legislatures can be found in the form of Tamil Nadu Public Health Act 1939, the Goa Children's Act 2003, the Bombay Children's Act 1948, the Assam Children Act 1970, the Andhra Pradesh Right of Children to Free and Compulsory Education Rules 2010. It is important to mention that the state of Kerala is the only state that enacted rules to provide for free and compulsory education to the children below the age of 6 years under the Right of Children to Free and Compulsory Education Rules 2010, and this can be referred as the initiative on the part of one state legislature or the legislatures of other states also follow the same initiative done by the Kerala state legislature, then that would be the great contribution of the state legislatures with regard to the protection of right of care, protection and education of early childhood. We have seen that what is the international law relating to the early childhood care and education, what has been the initiatives on the part of union legislature with regard to the care, protection and education of early childhood, and the legislations which have been made by the state legislatures. And therefore, we can conclude with the remark that though the different aspects of the care, protection and education of early childhood have been dealt with by the union legislatures and the state legislatures, but still the specific law dealing exclusively with the topic of subject of early childhood care, protection and education is still not seen, and therefore it is the need that the legislature should come forward to take care of this important issue, and accordingly there should be the amendment in the constitution under article 21A in accordance with the Venkatachalaya Commission report or recommendations of Venkatachalaya Commission. The constitutional amendment should be done. The amendment should also be made in the Rights of Children to Free and Compulsory Education Act 2009, and all the state legislatures should also take the effective initiatives on this part. Thank you very much.
Hello, good morning everybody. I am Raghunandan Sengupta. So, I will just give you a very brief excitement area of finance, which is quantitative finance, and that has a huge market starting around about 10 years back, and it is exploding exponentially. So, what do we mean by quantitative finance? Quantitative finance is actually the application of different mathematical and statistical techniques in the area of financial markets, be it say for example derivative pricing, be it in the area of say for example portfolio management, be it in the area of asset liability management, be it in the area of portfolio management. We see that the application has exploded in such a way that there is a huge opportunity for people who have a quantitative background in mathematics and statistics. They can utilize those in the area of finance, but obviously with some prior knowledge of finance as a subject. Now, when we say about quantitative finance, as I said, it is an area of applied mathematics and statistics applied in financial markets. Use of different areas, if somebody is interested to know, we have stochastic calculus, we have derivative pricing, we have operation research, we have quantitative techniques like differential equations, stochastic calculus, time series, and they are heavily used in the area of quantitative finance as I mentioned. Now, we all know that in 1997 the Nobel Prize in Economics, so it is basically the Nobel Memorial Prize in Economics was given to the work of Merton and Scholz in the area of derivative pricing, and after that there has been exponential increase in the area of quantitative techniques in quantitative finance and in the area of different type of derivative pricing. With the advent, moreover with the advent of high ended and sophisticated computing data, big data has come in a very big way, where application areas starting from computing, from different type of algorithm design have been taken up in such a big way that nowadays at least we are able to understand that how high frequency data algorithm trading can be utilized using the concept of quantitative finance in the area of finance as such. But there is a flip side also, obviously when there is a huge amount of development. So, obviously due to some regulation errors or something, there has been some pitfalls, which I think is should be a bullet point for people who are really interested to take up quantitative finance, they should be aware. So, consider the financial crisis in 2008 and later on, and we are seeing different banks are failing, different financial institutions are facing a problem, countries are facing a problem like in Europe, in USA. So, what should be done? So, the main thing is that even if you know the technique is best for people who are investors, who are private players, organizations like banks, governments should use these techniques in a very somber manner, such that the application areas of quantitative finance using the techniques which we learned can be utilized in the best possible way to garner the overall the in depth knowledge a person has in trying to utilize these quantitative techniques in finance. And I am sure that people who have the background, who have the knowledge, who have the sophistication, who have the knowledge of the society can definitely use quantitative finance in a very big way in trying to make their mark in this exciting field, which you are going to see in years to come. And I am sure it will be a very exciting learning tool for all the participants who will take quantitative finance as a subject in years to come. Thank you, and I wish all the participants all the best and best of luck for the programs they will take. Thank you.